Hello, and welcome to the first in a new series of podcasts produced by the Global Judicial Integrity Network at the United Nations Office on Drugs and Crime. These podcasts will promote peer learning and the exchange of good practices in strengthening and upholding judicial integrity. Today's podcast will focus on gender-related issues in the judiciary, including preventing sextortion, an issue defined by the International Association of Women's Judges as the abuse of power to obtain a sexual benefit or advantage. Our presenter for today will be Justice Tilakawardane of Sri Lanka.
Justice Shiranee Tilakawardane, it's a real pleasure to have you here in our JUICE studios today to talk about some very important things. Can I start the conversation with a question to you? You've broken through many glass ceilings as a woman in the judiciary. Could you tell us about your professional background?
I have 39 years of experience in the legal field, becoming the first woman in Sri Lanka to be appointed as a state counsel in the Attorney General's Department, as a High Court judge, the first woman judge of the Court of Appeal, and the President of the Court of Appeal. I was also the first woman Admiralty Court judge. I have worked for more than 10 years as a Supreme Court judge and also as an acting Chief Justice. And in these capacities, I have experienced and worked in all fields of the law, both criminal and civil, constitutional and human rights laws, in the writ law, in commercial and shipping law, and cyber law. I have also for 37 years worked and studied with great interest the rights of women and children, and recently being involved in the electronic media and its impact on violence against women and children, in particular in the cybercrime and in the field of child pornography under the Budapest Cybercrime Convention, and have wide knowledge and experience teaching judges as well as other players and stakeholders in the administration of justice.
How would you suggest improving the representation of women in judiciaries moving forward?
I truly believe that not only do we have to improve the representation of women in the judiciaries, but putting measures for there to be a sustainable representation of women so that we have an inclusive and representative judiciary that embraces diversity. Having just returned from the IAWJ conference in Buenos Aires, it is interesting. The theme of the conference was more women, more justice. But there are many barriers to be surmounted. The women who are appointed often find themselves stifled by patriarchal attitudes around them. And the appointments given to them sometimes are stereotypical appointments, where a woman will be sent to the family court, and where suitable appointments in accordance with their merits are not given to them. There is a supposition that they cannot do it. And these come from certain beliefs and attitudes that have no basis in today's modern world. And the only way to set this aside is to break the mold of patriarchy. And this is a priority. Where women's promotions are concerned, often their upward movement is hindered on cultures and religious beliefs. And though culture and religion itself is dynamic and changes through the years, women have remained the mascots of a very repressive culture and religions. They are not given advantageous positions which slows them down in their career paths. And where such gender myths and stereotypes discriminate against them in the trajectory of their career paths, they have no redress. After all, how many women chief justices do we have? Most importantly, attitudes have to change. Gender stereotyping has to be recognized, and an effective process to counter the adverse effects have to be put in place, which has to be both efficient and effective to afford redress to those who come across such barriers in their path. Complaints mechanisms and processes has to be easy and accessible. Ultimately, every law and policy that protects patriarchy has to be struck down. and most importantly, if women are to make a success in their careers, there has to be and there must be shared parenting.
Tell me, Justice Tilakawardane, have you ever encountered cases of sexual harassment and sextortion while working as a judge?
In South Asia, and I would think in countries like Africa, where there's a very high place given to culture and the subjugation of women, there are very few cases that are instituted in the courts of law. I have personally encountered many complaints from both lawyers and judges. But the social stigmatization and the personal ostracization makes them hesitate to go public on matters like this. The process of going through the courts disempowers them further and re-traumatizes them. Often, such situations are trivialized, and until the media publishes it or makes a sensation out of it, such complaints do not get the strong action that it merits.
What kind of environment leads to these situations? And can you tell me what leads to sextortion and how can it be prevented? And how do we break this silence about sextortion? What do you see as the main barriers in the effective fight against sextortion?
As I see it, the biggest problem is the objectification of women as property. It begins through the religion and cultural perspectives, which is often based on the superiority of men over women. Even the Roman Dutch law directly refers to women as chattels or property belonging to another, often the male figure. The understanding that equality of all includes equality of women, and the fact that they should have equal rights and equal protection of the fundamental guarantees of human rights is negated by myths, stereotypes, and cultural beliefs and attitudes. The media and internet spawns an ideology where violence against women is advocated with impunity and normalized. This culture has to change radically. New standards have to be set and enforced strictly. Well, what leads to sextortion and the impunity with which it is carried out are the reasons that I have set out in answer to my other questions above. Gender stereotyping, the lack of equality, the non-recognition of women's rights as human rights, the patriarchy that is rampant and where everything is viewed not through the lens of human rights and equality, but through the lens of patriarchy that is entrenched through culture and beliefs. And sadly, it is always against the women and the children, and this affects the disadvantages that society places upon them through such conduct and behaviors that we take so much for granted. It's such a wide topic that I need to be very specific. So I will take the example of how one would deal with a specific case where there is sextortion by a judge. And this is the model that will have to be developed in both sextortion and in sexual harassment when dealing with it and moving forward. First of all, it is to be observed that such conduct can be prevented by meeting the need for new standards of judicial conduct and accountability and integrity. Now, as you know, the Bangalore Principles of Judicial Conduct 2002 intended to establish standards for ethical conduct of judges, and the principles provided for effective measures being adopted by national judiciaries to provide mechanisms to implement these principles. The principles continue to be relied upon by states in preparing their own codes of conduct, and thus has a far-reaching impact in order to incorporate such measures. And in drafting of these codes of conduct, the following must be carefully considered. First of all, the measures to tackle sexual harassment and sextortion should not be generic. That is, a definition of sexual harassment must be provided and must be provided in great detail, describing the different ways in which sexual harassment could occur. And the more details that are given, the more effective will be such definitions. And the definition must be sufficiently comprehensive and not limited to vague or nuanced references. Because often, especially in sextortion, because of the lack of a legal definition, there is no consistency in the prosecution of sextortion cases, as there is no crime of sextortion that exists at the moment. So they go under a medley of state and federal laws, or sometimes through criminal laws. There is also a great inconsistency in the sentencing. There has to be a more uniform sentencing, and the IAWJ observes that even statutes that are designed to reach the abuse of authority to obtain sex are unlikely to encompass all types of sextortion. For example, in Tanzania, it applies onto situations involving the rape of a girl or a woman in the person's official custody. There has also got to be inclusion of such definitions within the Bangalore principles, not only under equality, because sexual harassment and sextortion impinges on other values as well. For instance, integrity, equality, and propriety. And then it also has to be included in the commentaries and the implementation measures. Another thing that one has to consider is that if we are to talk about judicial accountability mechanisms, such mechanisms should monitor and address sextortion and sexual harassment. Now, with the #MeToo and the #TimesUp movements, people are increasingly aware of the fact that they have a right to speak out against sexual harassment and sextortion, and feel solidarity with others who have undergone such similar experiences. States must provide avenues for such persons to report issues of sextortion and sexual harassment. There also got to be an increasing transparency and access to data collection of sexual harassment and sextortion by public officials in the course of their duties. Often, until a newspaper reports a matter, these cases are kept under wraps and rarely made public. And there's a lack of transparency of the judiciary. Sometimes there are threats and intimidation of the victims, which also must be addressed if we are going to see a transparent system put in place. There is also a very important matter that one has to consider when you're talking of this kind of instances like sextortion and sexual harassment, because one has to understand the nuances that exist. You have to understand the stratification of power or the imbalance of power between parties. You have to understand that there are issues of confidentialities and other factors which sometimes are likely to undermine the efficacy of such measures. There are a lot of challenges to the measures that even already exist, because sometimes the process could be undone by the judge who is being investigated retiring, and then the whole process comes to a halt. I would recommend that in matters like this that there is public censure, at least of the judges, if they are found guilty, to have suspension without pay. And if they are serious enough, that there be a movement to remove such judges from office.
You have worked training judges. Do you think that gender-related issues needs to be incorporated into the trainings?
The answer is obviously yes, but we also have to develop best practices for judicial training that addresses integrity issues such as sextortion and sexual harassment. We have to be able to identify these issues through training which is focused on sensitizing judicial officers to inherent gender-based biases. Training should include an overview of what to do when one faces a situation of sexual harassment or sextortion. It also has measures to enhance the efficacy of such training program. Judicial training program should not merely be focused on avoiding liability, but should provide a wide and overarching education about what constitutes sextortion and sexual harassment, how such conduct should be avoided, and how to deal with allegation of sextortion and sexual harassment. Judicial training should combine diverse methods of training, including lectures, in-person small group sessions and individual trainings. Training with regard to integrity issues such as sexual harassment and sextortion should not be one-off programs. Rather, such training should be incorporated into training at the inception of a judicial officer's career, continuous training, and specialized training.
The hashtag #MeToo movement advocates openly discussing sextortion, as does the IAWJ. So what are your thoughts on this approach?
While it's a wonderful movement and it has broken down many walls and people are being outspoken and there's a light that is being shone on what has been going on for many, many years, I don't know how far that would work in South Asia with all the cultures and the barriers that people have of speaking on such matters. I think in countries like India, it would be successful. There might also be problems that we might have to face if we start a hashtag #MeToo where the complainant becomes a victim, not perhaps by that particular offender, but others who will marginalize the person or ostracize the person, which is why the victims of rape are often reluctant to come forward and make complaints. If we could have such movements in the rest of the world, it will bring about sensitization and awareness of the enormity of the problem that is going on and the immediate need to take steps to prevent this being such a horrible scar on society.
Thank you, Justice Tilakawardane, for your insight on this topic. We hope that this interview will, in fact, raise awareness about gender-related issues in the judiciary. To everyone listening, stay tuned for our upcoming podcasts in this series of the Global Judicial Integrity Network.